So today we're going to talk about board oversight. And this is our second major topic in the duties that directors have. And these duties are sometimes phrased as the duty of care and the duty of loyalty. And yet here I am presenting this concept of a duty of oversight as almost a third duty. And that's not a well-established principle. There's some debate about whether the duty of oversight is a separate duty, or whether what I'm really talking about today falls within the duty of care or the duty of loyalty. I'll leave that for you to decide once we've covered those lessons, but I will, during this lesson, explain my reasoning for considering it to be a separate duty, and I think that's especially true because of some evolution in statutory law, like Sarbanes Oxley. And as a reminder, these duties are what give shareholders the right to sue. So we're in our chapter on shareholder litigation, and we know that shareholders can sue either in a direct lawsuit for harms to them as shareholders to their own rights, or they can sue derivatively, essentially causing the corporation to sue its directors, and they can do that when there is a harm to the corporation. And so failure of a director to provide oversight can result in legal liability and a lawsuit to the director. And whether that's framed as a duty of care claim or a duty of loyalty claim or something else tends to have a big impact on how that case will be resolved. So what we'll talk about specifically is we'll begin by reviewing some of the director functions and talking about what directors are supposed to do and what is the sort of lower limit of what they must do to avoid liability, and a more aspirational standard of what they ought to do in a perfect world. We'll talk about the classic concept of board supervision, which is a very low bar, and we're going to use the case of Francis with Miss Pritchard, one of my favorite characters in corporate law, the quote-unquote dummy director. And Miss Pritchard is going to show you the very low bar that we found under the classic standard. However, that bar seems to have been raised to a certain extent by various common law and statutory modernizations that have come to pass. And so we will talk about a series of cases beginning with Caremark, and also the Stone v. Ritter case will fall into the category of the modern corporate duty of oversight, at least the duty requirement of supervision. And we'll talk briefly, really briefly, about Sarbanes-Oxley and how that has created some additional duties of oversight. Well, I keep calling it that. Well, they've created additional duties of supervision, which I think can be well categorized as duties of oversight, but we'll conclude by asking that question. Is there really a duty of oversight, or in fact, is that better understood as an aspect of the duty of loyalty or the duty of care? And I'm sure what you'll all want to know is, then how do I approach that if I'm asked an exam or bar type question? So we will cover that aspect of how to categorize and couch these aspects as well. I think the short answer is you can approach it either way. And once we realize that duty of care claims are essentially going to fail, we'll see effectively that we have to put these claims in the category of breaches of care, of loyalty, or call them something else, because especially if a corporation has elected exculpation, which you may remember from our online lesson last week, duty of care claims are simply going to fail in most instances. So what are directors supposed to do? What are some of the functions of directors? Well, I think there are two main categories of functions of directors, and one is to make decisions. I mean, you can picture a boardroom, right? And when you picture a boardroom, what do you envision them doing? Making important decisions. Who to hire, who to fire, buy, sell, move into this line of business, divest this line of business. Those are all decisions that have to be made. But corporations can also get into trouble sometimes. In fact, there's a lot of laws that pertain to corporate activity. And directors also have an obligation to oversee the business, to keep it out of trouble in a number of ways, both financially and legally. And I see these aspects of keeping it out of trouble, for example, to not violate anti-money laundering laws. Right? That's a legal risk that someone in your company, if you have a bank, there's a risk that someone will use that bank to launder money, and that will create liability for your bank. That's a legal risk that the board might need to watch out for. Or the Foreign Corrupt Practices Act, which basically says your employees can't go around bribing foreign nationals. And so that's another aspect of the duty of I see oversight. You have to watch your employees and monitor them to make sure they're not bribing people in China. Right? So I think these are both areas that we have to think about director functioning, both in running the corporation and making affirmative decisions, but also this role of monitoring to make sure that things don't go terribly wrong. Now, under the classic case, there was a very low set of expectations for how much monitoring a director would have to do. I'm not going to go over in any detail a case that is no longer good law, but in Graham v. Alice Chalmers, the case basically said that directors only have a duty to respond to red flags, like a problem that's just right in their face that's announced to them. I'm not going to go over that case because I think it's confusing for students to spend a lot of time on a case which is not good law. But I do want to let you know that that's how it used to be phrased. There was actually some colorful language, and I have this lovely picture of a ferret because the case said, I'm sorry, I know you all looked at me like, oh, where's the ferret? Sorry, I don't have that slide in here. But that case held that there was no duty to ferret out wrongdoing, right? And so you can picture the ferret out wrongdoing, and there's only a duty to respond to red flags. But that's no longer good law. However, I do want to just cover the classic case of Pritchard, in large part because it's a lot of fun. We will spend more time on the heightened expectations that seem to be present in modern oversight cases. Caremark is a major case that we'll spend significant time on because it really changed the landscape for how people thought about liability for directors for failure to monitor. Up until then, that bar was so low. We had really lowered expectations. But those expectations were increased after Caremark and seem to continue to be increasing under law, maybe even creating a new duty of oversight in addition to the duty of care. There's also discussion, by the way, while I'm just talking about like new and additional duties, there's some talk about a duty of obedience that requires a director to follow the law even when it doesn't benefit the corporation. I think this is an interesting concept, at least worth footnoting. The concept here, again, the duty of obedience. Basically that directors should cause the corporation to act lawfully, even when acting unlawfully would not harm the corporation. And there's a lot of debate over whether or not that's actually true. Most scholars seem to find, and I think most directors would agree, there is no specific duty of obedience, in the sense that it's very much a corporate social responsibility kind of position. If you think corporations exist by the grace of the state and owe a duty to society, you may also feel that they owe a duty of obedience to the law so that they don't violate the law of the state that permits them to exist. On the other hand, if acting illegally is not going to result in much harm to the corporation, why should the directors be so careful about it? Why should there be a heightened expectation? Let me give you an example. Has anyone here ever double parked their car? Ever? Anyone? Sure. Right, you double parked your car because you ran into the store. You know, can anyone think of a corporation that tends to double park its cars pretty often? I was driving here today and I drove around one of these delivery vans. Oh, well, yeah, but that's actually that's a little different because that driver is theoretically an independent contractor. That wouldn't necessarily create liability, yeah.
It's either mail or FedEx?
Yeah, FedEx. And forget that U.S. mail is U.S. government service, but FedEx, right? Like, how often do you see a FedEx truck parked somewhere that says no parking? All the time. Now, double parking is illegal. There's a law that says you can't park here, so when you park there, it's illegal. If there was a duty of obedience, FedEx directors would be liable for not monitoring their delivery drivers and prohibiting them from double parking. But you know what? That would be really tough on FedEx's business model. As many of you who might have double parked at some point in your lives have recognized, following every single law to a T is not necessarily efficient. You might know that you're risking a $50 ticket by parking your car like that, but you just really need to get that errand done. And it's up to you to decide, how you would deal with that. But From a corporate perspective, FedEx seems to have made the decision that getting the packages there on time is more important than sort of following the letter of the law. And if they get a couple $50 parking tickets, so what? So what? So it doesn't seem that there's an overall duty of obedience. But if the penalty for double parking was $1 million, well, maybe you wouldn't do it. And maybe FedEx shouldn't do it. Maybe because that could result in real harms to the corporation, picking up bunch of $1 million tickets on a day-to-day basis. And so if the nature of that, now we're getting into an action which can really harm the corporation. The line's a little fuzzy, but for those reasons I don't think there's a duty of obedience, but you should know that that's a theory that's out there. The other aspect, is that a doorbell? Oh. Does that happen to this class of 16? It's louder than usual. Okay. Does anyone? Yeah. Why would a bell go off at 6:15?
Maybe it's like a Bible verse or something. Yeah.
Oh, like John 6:15 or something? Maybe. Yeah. Yeah. It would usually go off, I would think, at noon. That would be like the time I would most expect a clock to go off. Okay, that is neither here nor there. It's 6:15 for those of you who are, now you can set your watches to it. How about a duty of good faith? That's the other kind of proposition, is that there is this duty of good faith that exists outside and beyond the duty of care and duty of loyalty and maybe the duty of oversight. There is a duty of good faith in all contracts, and there is an understood duty of good faith that directors owe to shareholders, but it's not considered a separate duty. The duty of good faith is really an aspect of the duty of care, the duty of loyalty, and maybe the duty of oversight. So the duty of good faith does not create liability in itself, but failing to act in good faith can be one of the factors giving rise to a breach of loyalty or breach of care claim. So in short, at least in the modern context, there's at least for sure the duty of care and the duty of loyalty, and I'm fairly convinced there is no duty of obedience. The duty of good faith is an aspect of the other duties, and I will posit to you that the duty of oversight is a good way to understand this middle area where there is liability for a failure to act. Because duty of care claims deal with when a director has acted and acted wrongfully. It seems to me that the failure to act is somewhat different and requires a bit of a different analysis. All right, let's talk about the classic example with our friend Ms. Pritchard. So Ms. Pritchard is the classic dummy director who set really a very low bar and managed to miss what is an exceptionally low bar of liability for directors. And so what is this low bar? In this case, the court literally said that a director cannot protect herself behind a paper shield bearing the motto, dummy director. That's not a very high standard, and here we have an example of a person who failed to meet it. In this case, Pritchard and Baird Incorporated was a closely held corporation. Now, a closely held corporation is a little distinct from a lot of the corporations we talk about because most of the corporations we talk about are public, and that means that they're traded on a stock market and often have millions of stockholders. And so they have a very, very dispersed ownership. Now, we talked last time, two classes ago, about how institutions were buying large blocks of stock, but in general, these public corporations are owned by millions of people, and the shareholders are a very diverse and dispersed group. Now, in a closely held corporation, on the other hand, you typically have very few shareholders, often held by a family, sometimes an individual. There are actually separate statutes. You can organize a business as a closely held corporation, and you have fewer obligations to hold board meetings and things like that. So in this particular case, this was a closely held corporation, and so I think that's a factor in the backdrop where maybe in a closely held corporation, we actually might expect the shareholders to be paying more attention because there are fewer of them and they have more rights to them. So maybe, in fact, in a closely held corporation, we would have even less of a duty of directors because the shareholders will be paying more attention. And so we have lesser obligations. And even so, it wasn't met here. And what did they do? What did this corporation do? Does anyone remember? What was the business of Pritchard and Baird? Yes?
We did reinsurance broker.
Reinsurance brokerage, which I'm sure you're all very familiar with. Right, I had to look this one up as well. Does anyone happen to know what reinsurance brokerage is? And again, I had to look this one up. It's not a very common thing to think about, but it actually makes sense, and it turns out it's something that happens in many aspects. So when you buy insurance from an insurance company, they will owe you money if an event happens, which means they are now taking the risk of that event happening. So let's say you get car insurance. If you get car insurance and you have a $1,000 deductible, it means that you have only $1,000 of risk on damage to that car, right? And so someone else is taking the rest of the risk. What are they getting in return? They're getting premiums, a stream of income payments. And the insurance company, I work with Geico, so let's just use Geico. Could be Allstate, could be anything. That's your primary insurance company. I pay them, I don't know, let's call it $100 a month or something like that, and a $1,000 deductible. So that means that if I will pay them forever and ever until something bad happens to my car, and then I'm only liable for $1,000 of damage. Now, in addition to that, actually, a car can harm others, and so there could be a lot of damage resulting from a car collision. You have a variety of ways of doing quite a bit of damage with a motor vehicle, right? So now Geico has a lot of risk. I've moved that risk from myself to Geico. I'm only obligated to make my payments and pay the deductible, so I have a cap on my risk. Geico has effectively an unlimited cap or a very, very high amount of risk. Now, in some cases, Geico might have too much risk on its books, and in order to get rid of some of that risk, it will sell the policy to someone else. And just like I'm paying a certain stream, Geico can turn that around, and essentially those payments will go to a third party called a reinsurer. And now that third party is the one holding the bag if I get into an accident, and Geico just receives a lump sum based on how the reinsurance company values my policy. And by the way, the same thing happens in mortgages. The bank doesn't hold its mortgages either. The bank is going to sell those to another company, and that's also, we're going to talk about this more, I hope, next week. But one of the topics could be what caused the financial crisis. That'd be interesting. Some of you may be interested to understand what happened with the housing crisis. Well, these loans were not just sold as loans, but they were cut apart and packaged in mathematically complicated ways, creating various types of debt instruments that theoretically had different risk levels. And these cut apart and manipulated and repackaged and repackaged and repackaged mortgages were what Lehman Brothers was buying. And when it turned out that the mortgages were not as safe as they originally looked, balance sheets got flipped and crisis ensued. So we can, if you guys want to send me some articles on that, happy to share some of those. We can talk more about it. But many times, an institution that you deal with, like Geico has a lot of money that they put into advertising, they put a lot of money into marketing, into sales, and maybe they really are not so much in the business of holding risk, but in generating policies. And then they're going to resell those policies to someone who wants to hold that risk. Similar here, except Pritchard and Baird is a broker, so they're going to function as an in-between, helping arrange the deal between the policy holder and the insurance company and the reinsurance company. So on this chart, they're over here as effectively a reinsurance intermediary. So there is a broker that will sell the policy, and then once the policy is with an insurance company, Pritchard and Baird will work with the reinsurance company on a reinsurance contract. Danielle.
What would happen if the reinsurance company didn't have the money in the event that there was a loss?
So question was, what happens if the reinsurance company can't cover the insurance? Huge problems. California Fire is a good example, right? On the California Fire, several insurance and reinsurance companies, I don't know if any reinsurance companies actually went bankrupt. Some insurance companies did because they had too much risk on their books. The reinsurance companies tend to be huge. Like, I think there was something like 6 of them, and they're all in London. I don't know that much about the industry, but I think there's only a very few exceedingly large reinsurance companies. And so they're well equipped to handle significant shocks in their risk portfolio. But something as large as that wildfire in California could potentially wipe out a reinsurance company, and that could cause some catastrophic problems for the entire economy. Doesn't seem to have happened yet, but hey, maybe that's a prescient way to think about what's on the horizon for potential new disasters, because in a way, Lehman Brothers was acting like a reinsurer for the mortgage sellers, and that led to the financial crisis in a significant way. So that's reinsurance, basically. And so back to our reinsurance broker, we have 4 directors in the company. We have Charles Sr., Charles Jr., William, and our good friend here, Miss Pritchard. And Charles Sr. was taking money, skimming from the company accounts, up until the day that he died. And then Charles Jr. and William continued to take their unfair share of the company's assets. Now, Miss Pritchard, who, by the way, had taken no interest whatsoever in the company while her husband was alive, was so unbelievably grief-stricken that her crook of a husband died that she fell into despondency, became an alcoholic, and never left her bed. And so there she is, mourning her crook of a husband who was stealing from the company, and not paying any attention to the fact that her children are continuing to steal from the corporate accounts. And in fact, they did more than steal from the corporate accounts. In this kind of business, it's actually even worse than that, because the broker actually holds funds for a period of time. It's kind of like an escrow agent, which we've talked about. So they don't just have access to corporate funds, they have access to other people's money. And so this is a big piggy bank, and not only is the corporation's money not your money, but the insurance company's money is not even the corporation's money, and it's definitely not your money, and you're the trustee over this, and that's what they were stealing from. So this is a big problem, right? This is a big problem, and the question really is, should Miss Pritchard have known that the kids were stealing from the cookie jar? In fact, not even the company's cookie jar, but really stealing other people's money that the company was a trustee from. And just by the way, why is this case Francis v. United Jersey Bank? Because this case went to bankruptcy, and this is not a typical shareholder derivative lawsuit, but the insurance companies whose money was stolen are suing to recover in bankruptcy. It's a procedural quirk that you don't have to worry too much about to understand the concept of a deficiency in directors, but you might have been curious, what's with the names in the caption? That's the brief explanation. All right, so I want to ask you to take a look at the following financial statement. Look at this and tell me if you see any problem with it. Does anything look unusual? Does anything look strange? Anything raise some question marks or red flags? Alex.
So not having an accounting background, it seems like kind of strange that the working capital deficit and shareholder loans seem to be almost equal with each other.
Yeah.
Does that mean that they're borrowing almost 100% of their money?
Well, actually, in some years, they're borrowing more than 100% of their money. So one thing that's interesting about this picture is that the shareholders are borrowing sometimes more than the company makes. In fact, in almost every year, they are borrowing more than the company is earning. Take a look at 1974, for example. Okay, and again, we're not accountants here, but let's read this chart. In 1974, how much money did the company earn? Around $876,000. In that same year, how much money did the shareholders borrow from the company? About $7 million. That's nuts. That doesn't make any flippin' sense. That is totally bogus, and that can't be good business practices. And you know, it only took us, without an accounting background, we're just lawyers, we hate math, and we could look at this and say, something's off. Miss Pritchard probably never even looked at a financial statement in her entire tenure as a director. And so we then ask, did Miss Pritchard, by not noticing this, was this the kind of red flag that should have alerted her to wrongdoing, creating a duty for her to act?
Wait,
Yes.
why is 74 an issue?
Well, they're all the years are issues because stockholder loans are unusual, period. But in 1974, the company is losing money. Every year they're earning less and less money. And despite that, the company is lending out more and more of its money to its own shareholders, noting this is a closely held company with only 3 living shareholders. And in that particular year, the amount of money they loaned to shareholders was almost 10 times what it earned. That's clearly unsustainable.
That column should be non-applicable or zeros all the way down.
Yeah, it should be zero, and it should certainly not be dramatically more than the company's making. This company is only netting $1 million a year revenue, and they're lending to the people that run the company loans of $7 million. Like, where's that money coming from? It's coming from either the corporate coffers in an irresponsible way, or worse, in this case, it was coming from money that they held in trust for others because they didn't earn it. Yeah, David.
I just think it's interesting that the third parties that were like giving money to the trust never demanded like any type of audit for years.
Right. Yeah, maybe things were different in 19... And why would you work with Pritchard and Baird? Like, why would you choose them to be your broker and trust them with your money? But I can't account for that. Yeah. Alex and Paul.
How don't they have financial statements for a whole year?
What's that?
How don't they have financial statements for a full year?
That's a good question. That's another problem, right? Like they missed. I don't know. That's a great question. I just have the data. I don't know why they seem to have missed an entire year of financial statements. Like they just didn't even collect the data. They just didn't file their taxes that year. I don't know. That's another red flag, Danielle. All right, so let's go back to the question issue. Did Ms. Pritchard violate the duty of oversight? Oh yeah, major breach. This is a major breach in the duty of oversight. And by the way, she was dead at the time, so this case was by her executrix. But she never made the slightest effort to discharge her duties as a director. This clearly does not meet the most minimal standards for duty of oversight, even under the classic low expectations. Danielle.
Why is she being singled out if the sons are still alive as well? Like they obviously, well, they're the ones stealing, but at the same time, it's also a breach of oversight because they're also directors.
So we'll come back to that next week or 2 weeks from now, because that's really a breach of the duty of loyalty, because they were actively stealing from the company and committing what was tantamount to fraud. So that's beyond a care violation. That's a loyalty violation. And I don't know why. My only observation would be that they must not have had any money to go after. I mean, you usually go after in litigation your deepest pockets. And it seemed like Pritchard had some money to recover. I assume that's why she was being sued. Maybe Charles Jr. Liked to go to Vegas and put it all on 13, and didn't have much to show for it at the end. So that's what happened here. And so it does teach us a few important things. It tells us, what are some things a director should do? What does the good director do? A director needs to become familiar with the business. I mean, that's not a very high bar, but and by the way, a director does not have to be an expert. John, you've been looking at this issue, right? And under the law, as I understand it, and I think, a director does not have to have subject matter expertise, but they do have to become familiar in the business. So if you have a company that makes pharmaceuticals, the directors don't all have to have degrees in biomedical engineering. But they do have to become familiar with the company's business and its business fundamentals. Things like at least the balance sheet and reviews like that. Although I think it's an interesting question whether they should have an obligation to do more. They certainly don't in the classic case. Although I think you're doing some research into this. Maybe part of the trend of more oversight will put a greater burden on directors to have subject matter expertise as well. Directors also need to get informed about corporate activities. They have an obligation to see what's going on. They need to attend board meetings. Like they only have them quarterly. She didn't even get out of bed, for crying out loud. So that's pretty lame. They do have an obligation to set corporate policy and direct the strategy to make sure the ship is not going to run aground. They hire and fire and pay the executives. They set the compensation of the executive team. That's an important function of the board. And they monitor the business. They have to monitor to make sure the business as a whole is not committing illegal, maybe some illegal, certainly not massive illegal conduct. Again, query, does the FedEx board have to make sure its drivers are not double parking? Maybe that's not quite the same as making sure that your officers are not bribing Chinese officials at the port to allow your goods to get in. They also, by the way, will have the obligation of running the company more directly if there's a crisis. If for example, if the CEO needs to be removed promptly and it's difficult for a period of time, the board actually sometimes does take a more active role in extreme emergency cases. And fundamentally, what was lacking here, they have to, in this process, object to problems of which they know about. they have to either object or resign, or maybe cause the corporation to sue. And what did Ms. Pritchard do? Right? She was drunk. She was completely incompetent. She was lackadaisical. She was entirely unconcerned. She made no effort whatsoever. This is not sufficient for even the most minimal duty under the and will not be given deference. Effectively, and this again is why I think that this is a bit different than a duty of care. The duty of care says that directors' actions are protected by the business judgment rule when they have paper and process. But that doesn't really, to me, define director inaction. This is really a case of an omission, not a commission. And here, because there is director inaction creating the liability, when should the business judgment rule apply to inaction, and when should the business judgment rule not protect inaction? Well, at least we have a low bar here. This was below the low water mark, and where the director is not going to meetings, not reading the financials, not even getting out of bed to notice the obvious that her children are stealing from the corporation, this is not enough. Which then leads us to what is enough. And I want to just give you a quick, I usually focus on Delaware law, but I want to briefly bring up the Model Business Corporations Act because it really distinguishes the difference between standards for conduct and standards of liability. And here's what I mean. A standard of conduct means what you should do, whereas a standard of liability refers to what you must do. If you don't meet the standard of liability, that's the lower expectations. If you don't meet the standard of liability, you can be sued. Now, if you don't meet the standard of conduct, you aren't necessarily going to be vulnerable to a lawsuit. You're not doing what you should be doing, but it's not quite enough to be sued. We've talked a bit about how the business judgment rule is akin to a standard of gross negligence, which means that a director can be slightly negligent and still enjoy business judgment rule protection. So the MBCA section 8.30 talks about this and says each director, when discharging the duties of a director, shall act in good faith and in a manner reasonably believed to be in the best interests of the corporation. And the directors, when becoming informed, shall discharge their duties with care that a person in a like position would reasonably believe under appropriate circumstances. Notwithstanding that it says shall instead of should or some softer language, liability doesn't seem to attach if a person fails to do that. However, 8.31 does discuss when liability will attach. It says that a director may be liable to the corporation if the conduct that's challenged is the result of a sustained failure of the director to devote attention to ongoing oversight of the business and affairs of the corporation. Now, these aren't particularly clear, and I don't know how much these terms are helpful. More than that, I just want to point out that there are sort of two watermarks. There is the mark for what it takes to be liable or not, and that essentially is equivalent to acting with gross negligence. But there is something more, a more aspirational standard that we would want directors to achieve a higher bar. And Professor Mel Eisenberg talks about this. There's Mel. Hey, Mel. He talks about this as the standards of conduct versus the standards of liability. And he says that a standard of conduct states how you should play a role, whereas a standard of review or standard of liability, he calls it a standard of review, a standard of judicial review, meaning a standard of liability states whether a court should impose liability. In the real world, standards of review in corporate law diverge from standards of conduct, right? So we have, again, this concept of a high bar and a low bar. And the low bar is not necessarily what you want to counsel. Now, here's the thing. If you're advising a corporation, you're trying to tell a director how they should act, you could tell them, just shoot for like a quarter inch above the low bar. But that's risky because these aren't clear lines in the sand. It's much better, obviously, for any number of reasons, including your own ethical compass, to suggest that a director should achieve the standard articulated in 8.30, the standard of conduct, the higher standard. For one thing, it means that they're well above the standard of liability, and they have a much reduced risk of a lawsuit. It's also probably better for the corporation, and consult with your professional responsibility professor, but generally lawyers encourage their clients to not achieve just the very minimal standard to avoid liability, But if there is, in fact, a standard written in law that they should be trying to be more careful, that is where we should recommend our clients to behave. There's another way to frame it. It's also sometimes talked about misfeasance versus malfeasance. And so these to me are sort of synonymous. And so you might have read, what is this misfeasance, malfeasance? To me, misfeasance and malfeasance are similar to standard of conduct and standard of liability. If a director's action is the result of a bad decision, or it's just foolish, but the action's taken in good faith, that might be negligent, or it might simply be a good faith mistake. That will only amount to misfeasance. Yeah, it's lower than the standard of conduct that we'd like to see, but misfeasance is not enough to generate liability. Whereas if the actions were prohibited or made in bad faith, they fall below the lower bar, below the standard of liability. The business judgment rule will not apply. We effectively at that point have gross negligence or worse and potential liability for directors. So there's a couple different ways to frame the same problem. They're all slightly fuzzy concepts, but at least now you see that there is a aspirational standard of conduct. Falling below the aspirational standard can be misfeasance. But so long as a person acts with good faith and it's not grossly negligent, liability will not attach. However, there is a lower bar that you must clear in order to avoid being sued. We can call it gross negligence, we can call it the standard of liability, we can call it malfeasance. But below that, that's where a shareholder lawsuit will prevail against the director. Now that's the classic standard. So any questions sort of on that before we talk a little bit more about the modern corporation? Yeah, so let's talk about the modern corporation. And by the way, I selected this image. I really enjoy this image because this is a famous classic painting reconceived in a modern line drawing concept. And it signifies not just the change from the classic to the modern, but also the wave to me signifies the impact of the case that we're going to discuss, which really it really hit hard on the Caremark case. And now we find that there are potentially new and heightened liabilities for oversight failures that did not exist before. So much so that I think there is, at least we can conceive of a duty of oversight emerging from the Caremark case. Before I move on, I just want to remind you the traditional approach. Right? Let me, in fact, get back to an older slide. Any of these here? That one. That's a fun slide to keep up here for it, right? Right. The older standard, the traditional standard, we saw in Graham v. Alice Chalmers, which I think you read, but is not, I think, fundamentally important. The case here held the standard that a director does not have an obligation to ferret out wrongdoing. Doesn't have to look for problems. But if a problem presents, if a red flag emerges, and it's obvious, then the director needs to act. In the case of Miss Pritchard, she did not become aware of what was an obvious problem. The kids were obviously stealing the money. All it took was one glance at that accounting statement to see that something was truly wrong. The modern standard requires more of corporations, requires directors to actively engage in supervision and supervise against at least legal risk. And the reason, by the way, that we're going to talk about the financial crisis in the next class, and maybe our first case of Citigroup, is whether or not directors have to watch out for business risk, like what happened in the financial crisis, is still an open question. Directors certainly are sued when a corporation makes a bad business decision, but they tend not to be liable. Directors are permitted, expected, in fact encouraged to take business risk. Legal risk seems to be a bit different. That's why I bring up the case of FedEx. The cases that we see shareholders either prevailing or coming close to prevailing have to do with directors not watching out for legal risk. And so this is actually helpful for those of you that think you might be interested in compliance. It really shows the importance of having compliance management and reporting systems, because the failure to have these systems can result in director liability. So let's talk about the case. So CVS is now merged with Caremark, but Caremark used to be an independent company, and it was at the time. Obviously now is CVS Caremark. So what happened in this case? Well, we have a corporation which has employees, and the employees sometimes violate the law, right? I mean, that's sort of the nature of having employees. Now, if they violate the law in their own time, that's one thing. But when your employees violate the law in their course of business, you can get into liability as a corporation. And there might be a failure to provide training. So in this case, the plaintiffs claimed that the Caremark Board of Directors breached a duty of care. And I mention that and I emphasize that because in later claims we'll see a claim of breach of duty of loyalty. And again, this is why I think the duty of oversight should be seen independently from the other two, because sometimes they're brought as care claims and sometimes as loyalty claims. That doesn't make a ton of sense to me. Why can you bring them? The same action can be brought as either a care or a loyalty claim. I think it's because we are at a state of the law where we don't really understand how to deal with oversight. And it is an independent duty. But fine, that's my academic soapbox. I'll get off that for a sec. So this is a duty of care claim, and they claim that they breached that by failing to monitor their employees, who then were providing kickbacks, referral kickbacks to healthcare providers. So anyone here know what kickbacks are? Jay, do you want to explain?
So it would be like, some kind of like, not even like a commission, but something you would give back, monetary benefit you would give back. So if like, you were engaging in a deal with like a CVS, like supply provider, and they provided you with a kickback, it would be some kind of monetary.
Has anyone been following the opioid crisis? Anyone, like, is that an interest of anyone for kind of research interest? Yeah, so both of you can maybe talk about it a little bit. Can you see the connection here? Like, how were doctors encouraged to prescribe opioids?
Pharmacists giving them, like if you would prescribe so many of this drug, you'd get laptops or trips to Bermuda or lunches brought in every week for your staff.
Yeah, so doctors were actually getting a benefit for prescribing more opioids. Can you see a problem with that? What's the problem with that?
Overprescribing.
It encourages them to prescribe more, and it's not just even this opioid or that opioid, but like opioid prescriptions are going to go through the roof if for one thing, there's marketing that says opioids are not harmful, not addictive. There's people that really like them because they turn out they are addictive, and then on top of that, you're getting a trip to Bermuda. So you make your patient happy, you make money, you go to Bermuda, and you're told that you're meeting your standard of care in the process. That seemed to have led to some bad outcomes, potentially. But that's a good example of a kickback, because in this context, the drug company was essentially paying the doctor to prescribe the medicine, which is an improper and unethical kickback. So this was going on rampantly in pharmaceuticals, I guess, for a very long time, at least since prior to 1996, and I don't know, maybe forever. Just sort of the nature of part of the problem, by the way, is that if we want to talk economics for a sec, is that medicines are a type of credence good, meaning you don't really know necessarily if they're working. And so when things are hard to monitor, that creates a certain room for sort of mischief around it. And so there tends to be more problems where the end user is not able to really accurately measure the effectiveness of something, and so they rely on experts, and then that expert becomes a good target point for inviting, giving particular advice. I mean, you see this even now with like YouTube influencers who do like reviews of videos or highlight things. This is a problem now with Amazon reviews and in a number of areas where people are essentially given something and that might cause them to become less objective. Anyway, you understand kickbacks, right? So in this particular case, there was allegations of kickbacks. The United States Department of Justice and the United States Department of Health charged Caremark with multiple corporate felonies. So these aren't parking tickets, okay? Multiple corporate felonies that resulted in criminal and civil fines in excess of $250 million, which is actually a pathetically small amount given how much Caremark is making off of drug sales and things like that. But there is a huge impact to the stock price when something like this happens. It's obviously very embarrassing for the company. It hurts their reputation, et cetera, et cetera. So And this is always interesting, like how these charges are brought. This is, I'm sure there's someone who can inform me why, but the claim was actually under mail fraud. And so they pled guilty to mail fraud, which is kind of interesting. But in any event, they pled guilty, and so they admitted guilt. And so it wasn't even like a plea of nolo contendere and a settlement. So after they pled guilty to the government, the shareholders, who saw a huge decrease in their stock value and a huge decrease in the value of the company, because now the company, companies like this pride themselves on being well regarded, right? Trust is so important to a company that is giving you drugs. You really want to trust they're giving you the right drugs. And so this could really hurt the company. And so now we have a derivative lawsuit because the actions of directors have hurt the reputation of the company, and the shareholders then are derivatively impacted by that. And so they sue. And as you may recall from our previous lessons, if the shareholders and the corporation through its directors agree to settle, if the corporation and its directors agree to settle, the Delaware courts have to approve that settlement. So that's where we are in terms of procedure. It's sort of an interesting, unusual procedural quirk, is that in derivative lawsuits, the court approves settlements. You can't settle without a court approval. And that's how we get into the idea of whether or not effectively Delaware is going to say, yeah, there was a duty of oversight that was breached, or no. Because by approving the settlement, the Delaware court that approves the settlement is effectively saying, yes, a violation here likely occurred. Mallory?
If they have to approve it, are those things of record then?
Yes.
Oh.
Yes. Yes, I believe, yeah. And that's actually, I hadn't thought that one through. You're bringing up some interesting points today, guys, so I appreciate that. I actually hadn't, because you're right, like one thing that is kind of just stated is that settlements are hidden or obscured. And so in the case of settlements of derivative lawsuits, they should be publicly available because they're put before the court. They certainly would be available in some sense, maybe with a FOIA request. I can imagine they might be under seal, but maybe not. And maybe here we actually have a resource. I don't know if anyone, I see you have laptops, anyone wants to kind of Google that and see if you can, if you can find them. I imagine that you can actually then find settlements in this instance, whereas in most litigation you cannot find the settlement publicly. Yeah, Kristen.
I don't know about finding them publicly, but I know that they're still disclosed to your auditors at the end of the year. That obviously factors into
Interesting.
Yeah.
So at least they're disclosed to auditors, which might be, the auditors do get to see confidential information, but they have to be disclosed. So settlements have to be disclosed to auditors.
We would disclose them.
Yeah. Well, if anyone's kind of looking into that, you can just raise your hand and shout out if the settlements are available. That's an interesting just area for research as well, because again, settlements are usually something you won't find. It's interesting to find you can. So the plaintiffs sued for this duty of care breach and claimed the directors allowed a situation to develop and continue, didn't monitor sufficiently, and this created enormous liability. It wasn't just a couple parking tickets, $250 million plus huge reputational harm. They didn't bring a duty of loyalty breach claim. It was a duty of care breach claim. And the corporation sought to settle, which required court approval. And the question then is the court of Delaware going to approve this settlement and effectively say, yeah, Caremark directors could have been liable on a jury verdict? Yeah. That's why it's such a compelling case. Yes, the court did approve the settlement and effectively said that Caremark failed to monitor, failed to provide the oversight. It said there was a low probability of the breach, but not zero. And the business judgment rule would then not attach because the directors have a liability here for their failure to monitor. They failed to act. They didn't act badly. They failed to act. And this is the first time, at least as far as I know, aside from the kind of the obvious Pritchard cases, where a board of directors was held liable at a major public corporation in a big public way, was held liable not for acting improperly, see Van Gorkum, but for failing to act, for failing to monitor. What did they fail to do? They didn't make a plan. They had no oversight plan. They had no plan in place to monitor their employees to make sure their employees were not offering kickbacks. They had an obligation to create such a plan, and they failed to do it. And this is interesting. This is interesting because where's the limit on this? How much do boards now have to do to make sure their agents don't engage in illegal activity? Daniel.
So, why is approving the settlement conditioned upon the court declaring that there was in fact a breach? Because in a lot of cases, I mean, at least in medical malpractice, you can settle a case without admitting that you violated the standard of care.
Mhm.
Sometimes you just settle for cost of defense because it's going to be more expensive. to fight
But those
lawsuits.
aren't going to be court-approved settlements. So the court here would not approve the settlement if there was no chance of the claim proceeding. And so, it has to do with the complicated web of how derivative suits work and insurance and indemnification and all the other factors there. It's effectively a securities litigation question at its heart. But when the board approves this, when the court approves a settlement, one of the standards is there has to be some likelihood that the case could win on the merits. And they did say that, in fact, they even said in their settlement approval that there was a low probability, but not a zero probability of winning on this claim. I'm not exactly sure how low, but it was not zero. If it was zero, they would not have approved the settlement. And so they're opening the doors saying directors can be liable for this type of failure to act.
It seems like if it's going to reach the stage where the corporation has agreed to settle the case, that there is a basis to the lawsuit, then there would be,
Maybe, maybe not. I mean, people settle for all kinds of reasons. You settle anytime it's cheaper to settle than to proceed. And so, it could be a very small claim, and if the claim is for $10,000, you might just settle. I mean, some corporations have a policy of never settling. Like Walmart I don't know if it's true, but they claim they never settle a slip and fall case and that kind of stuff. But a lot of times the decision to settle is based on how much will it cost me to proceed, what's my likelihood of winning, how much will I pay out if I win, and if A is less than B, I settle. So it doesn't necessarily indicate that there's liability, but that simply the cost of litigation alone can be a reason, and litigation is inherently uncertain. And so there's a concern that if you put something to a jury, have you met, people? Like, do they understand this stuff? I don't know. I mean, we've been in class for half a year, and it's still a little bit hard. Imagine just your average person hanging around in Delaware. You put them in a jury, and you ask them whether or not the director should be liable. Are you sure they're going to get it right? Especially because it's a civil case, and so you don't need unanimity. You just need a majority. So what are the chances? And I don't even think you need 12 jurors. I think you need 6. So is there a chance that you could persuade 4 people that this huge corporation did a bad thing? Does that necessarily mean there's liability? So I think there's more to it than just if a corporation settles. And that's also, like, most of the time when there's a settlement, there's not a presumption of guilt. Here we have that settlement approval, which I think really added something. And there was this statement, again, this clear and unequivocal statement that there was a duty that could have been breached. Mallory?
Yeah, it's just all there.
It's all there. Yeah.
All the court documents like they would be, but weirdly, I don't know if they are making them do it, but they're like press releases about what they are. Like, that's what I found before I even the court documents. I don't know if
That's interesting. Like, I mean, on this particular case even.
just any.
Yeah, any of these settlements.
They just,
Well, I think we can understand the press releases in that if something bad happens, the corporation might want to control the message. And so if they get the press released out first, then maybe they, to a certain extent, control the message and how bad it is or how to interpret it. And I bet the corporation's press releases indicate things like a settlement's not an admission of guilt. That's a nice thing to say. If you're going to be if you're going to get on the New York Times in this article, Caremark settled, and note, settlement is, not an admission of guilt. Helpful if you can control that message. But there's your answer. So settlement agreements are available in the corporate context. Paul?
Yeah, only court-approved settlements are public record.
Only court-approved settlements. So there's
Those are confidential.
yeah. So it's a different kind of settlement. So that's just one more way to distinguish corporate litigation from the rest of litigation. Settlements are public, which actually might, just getting all, again, law and economics, you might change the incentive to settle. I mean, one reason people settle is because it goes away. This doesn't go away, does it, Mallory? It's right there in black and white, indefinitely on the internet. So definitely changes the nature of deciding to settle. All right, so we have this failure to monitor, and we've determined that in fact the corporation could have been liable, and we have what are now called Caremark duties. And the directors are going to try to address these concerns. And what are these Caremark duties? Well, first, a duty to attempt in good faith to assure that a corporate information and reporting system exists. Right? They had no information reporting system to see if their employees were doing bad things. Now there seems to be at least some duty to make a good faith effort to create some kind of reporting system, so you can see if your employees are engaging in these activities. And failure to do so may render a director liable under this standard. And again, this is not necessarily to say that a director would be liable, but we've opened the door, and directors who are going to be very worried about this type of personal liability are going to rush to create these type of monitoring systems, right? I mean, I kind of picture it this way. Obviously, this is like a security monitoring system in the picture here. You can't have like a, how do you really monitor this type of stuff? It's actually very hard. But, you'd want to go to court, and when you go to court, you'd want to say that you're effectively doing this, that you're effectively watching your employees to see if they're doing things that are wrong. And that could be by having some type of tag on an email. It could be training that you offer to them to make sure that they know what the rules are. It could be penalties if anyone is caught, making examples out of individuals who have acted outside of the scope. My good friend Ailey Elias is in the business of helping companies set up these compliance programs. He actually, I call him an attorney. He has a law degree, passed the bar, New York and New Jersey, but he doesn't consider himself a lawyer because his role is really quasi-legal. It's actually, it's an interesting, I think, line of work. But using that law degree to try to help corporations set up systems like this can be a really interesting way to work with corporations. And then what is the point of that, again? To help them avoid getting banged up, to help them avoid getting bruised and injured in litigation. All right, I always like to have a quote from the court, and Chancellor William T. Allen over here, he authored this opinion. And he did make the following point about when we'll hold directors liable, because he was careful to articulate that the obligation, a director's obligation includes an attempt in good faith to assure that a corporate information and reporting system, which the board concludes is adequate, exists, and that failure to do so under some circumstances may, in theory at least, render a director liable for losses caused by non-compliance with applicable legal standards. In other words, a director's duty of care is a duty that can be satisfied provided that information flows to the board, so that they have the information. I think in this way we can understand this as a duty of care issue, because just like in Van Gorkum, where we had a failure of paper and process, and therefore the decision was not protected by the business judgment rule, the failure to provide the type of information needed for a director to make an informed decision seems at least related to that in concept. So what would a plaintiff have to show? The plaintiff would have to show first that the directors knew, or two, that they should have known. So KOSHK, one of my favorite acts, known or should have known, knew or had constructive knowledge, that violations of law were occurring. And as we saw in our last case, as we saw in MBCA section 8.31, that these violations were sustained and systematic. It wasn't just that one guy once paid a kickback, but here, this was rampant in the organization. That the directors took no steps in good faith to prevent or remedy the situation, and four, that defendants did not establish an affirmative defense, that the defendants were not able to establish that the harm to the corporation was not caused by the inaction. So in order to prevail on a breach of oversight claim, or whatever you want to call it, breach of oversight couched in care claim, a plaintiff would have to show that the director should or should have known of a systematic failure. So now this is bigger than just red flags. So that was, by the way, the court's language. Sometimes reading the court's language is helpful, maybe sometimes not. I'm going to paraphrase. Effectively, the law before in Grahams v. Alice Chalmers is the court has no duty to ferret out wrongdoing, it only has to respond to red flags. Clearly, the board still has to respond to red flags. It has to respond to violations of law that it knows about. But now, it also has to respond to violations of law it should have known about. That it should have known about. Meaning that it has an obligation to make itself informed. If it does not take the action required to create information systems and is thereby having a lack of actual knowledge, right? The ostrich approach, right? Having your head in the sand is not going to protect the director from liability where they should have known of the liability. And this is clearly an extension of liability for directors in the oversight context and really change the way people practice. There's a huge aftermath from this, and practitioners, to some extent, interpret this to create a third duty. Your casebook authors disagree with me, which is why this lecture you'd be like, well, I thought I read. No, your casebook authors say that the duty of oversight, it doesn't exist, and there's the duty of care and the duty of loyalty. I think it's a very plausible argument, and they wrote the casebook, so. But I think that I have a good claim as well, because as we'll see in our next case, these duty of oversight cases are sometimes phrased as duty of care breaches and sometimes as loyalty breaches. So anyway, this was a major statement of the modern duty of oversight. Caremark set a new and higher legal standard governing a board of directors' obligation to supervise or monitor corporate performance. And in fact, suits about this, about failure to monitor, are called Caremark claims. And so it has that moniker attached to it as well. And so, as I suggested, this may create this new duty of oversight. But the standard is still not so low. In fact, as I've said, only a sustained or systematic failure of the board to exercise oversight, such as an utter failure to assure a reasonable information and reporting system exists, will establish the lack of good faith that is a necessary condition to liability. So we're not making it too easy, I think, at this point for shareholders to sue, but we have extended the duty of directors not just to respond to red flags that they know about, but ones they should have known about, which means they have a duty to become informed, which seems to me to mean they have a duty of oversight. But we're not necessarily requiring them to be smart. In fact, going back to Chancellor Allen, he says about directors, and I think, John, this is informative for your ongoing line of research. True, he was not very suited by experience for the job he'd undertaken, referring to the director. But I cannot hold him on that account. After all, it is the same corporation that chose him that now seeks to charge him. Directors are not specialists like lawyers or doctors. They are the general advisors of the business. And if they faithfully give such ability as they have their charge, it would not be lawful to hold them liable. This is stating that directors have an obligation to try to set up information systems in good faith, but if they try in good faith and do a poor job, they have committed misfeasance, not malfeasance. They may not have achieved the standard of conduct, but they have not met the standard of liability. If they try and they fail because they are incompetent, they will not necessarily be liable. Or, as my friend Alfred E. Newman would probably say, directors are allowed to be stupid, but not lazy, is effectively what it boils down to. Look, if you hire a director, my dad used to say, you can't fix stupid. I mean, if a director is stupid, they were stupid before the job, stupid during the job, and stupid after the job, which means the shareholders appointed a stupid director. So who's stupid now? The shareholders. How can they be saying the director is too stupid for his job when they're the ones that hired him? That's effectively what the chancellor is saying here. Whether a judge considers after the fact that a decision was substantively wrong is not the issue. The issue is whether or not the director attempted that in good faith. Now, not attempting it at all seems to be not in good faith, and in both of the cases, we have no effort. And in one case, we have someone who didn't even show up for work, ever, Pritchard, right? On the other hand, I'm sure that the Caremark directors were attending regular meetings, but they didn't set up a compliance system. They didn't take the effort they needed to become informed. And now the law says that even if directors are not actually informed, then they can still be liable if they should have known had they attempted to implement information systems. And this is even stronger now that we have Sarbanes Oxley. So the Sarbanes-Oxley Act of 2002 was passed in response to a couple of high-profile scandals. Enron, WorldCom. And these scandals, I mean, sometimes scandals cause Congress to act, and it's not, whatever. I have a whole theory about that. It's kind of reactionary. But the idea was that we're going to require by law, by federal law, for corporations to have more obligations of oversight and more obligations of disclosure, including independent auditors, which may be why you provide your settlement reports. It may have been something that was less required or maybe fuzzier before statutory requirements. And this also requires corporations to create internal controls. I mean, Sarbanes-Oxley is a big reason why my friend has a job, right? Because it requires all major corporations to set this up. Here's your handy-dandy flow chart. I'm sure that's real readable and clear. Basically, though, it's saying that a corporation has to set up internal controls as a matter of statute. So now a failure to set up internal controls is not just a potential violation of a Caremark claim, but also a potential violation of Sarbanes-Oxley as a matter of federal law. So what do these compliance programs look like? Well, Sarbanes-Oxley Section 404 calls for a management assessment of internal controls and says that it requires each annual report of an issuer, a publicly traded company, to contain an internal control report. So now these public companies are making public reports about their internal control systems. What do the reports say? They state the responsibility of management for establishing and maintaining an adequate internal control structure and procedures for financial reporting. And they contain an assessment at the end of the fiscal end year of the effectiveness of the internal control structure and procedures that they're following to report. Look, these were pretty controversial. I think they remain controversial, and it's not entirely clear if Sarbanes-Oxley is efficient or not. It certainly was popular at the time in light of all the harm that was created by the failure of WorldCom and Enron. And not just the shareholders, but many employees lost their livelihood as a result of that. And there were entire governments that depended on Enron for power supply, things like that. But these controls are very expensive. As I mentioned, my friend has a job, and he works for a firm, and they have lots of people that have a job. This created a lot of jobs, but, I mean, you can create jobs by making regulation, but it's not clear if these jobs are efficient. Don't tell Ailey I said that. No, he'll agree with me. But look, it's the law, and that's what Congress decided. But I think it's particularly problematic with regard to small companies. The one issue that I take with these type of regulations is they tend to draw strict lines in the sand at some type of number. And so in this particular case, the SEC allowed companies that had less than $75 million of market cap to delay their implementation. That's sort of an artificial line in the sand that did help them get up to speed a little bit, but this created some odd incentives right around that junction. And you can read some of my other work on this. I think it also has been one reason why companies are more hesitant to go public. This made being public more expensive. It doesn't apply to private companies. So now public companies have this additional extra cost. They have additional liability. I mean, it costs money to write the report, right? It creates liability because now if the report isn't good enough or something's wrong with the process, the directors are sued. It increases the price of director and officer insurance because it increases the liability. It can distract management from other tasks, which increases the cost because now they're dealing with reporting as opposed to running the business. And it requires them to disclose information. And all this only applies to public companies. So it stands, at least to me, it stands to reason that private companies now have an additional advantage over public companies. And this combined with the Dodd-Frank Act of 2010 and other acts that have applied to create additional costs for public companies, I think is part of the reason why we see fewer initial public offerings and a rise of large private corporations. So we have a number, I actually have lost count, but there are well over 100 corporations today that are private and worth more than $1 billion. This was virtually unheard of in 10 years ago. So I think laws like this have a place, but I think we also need to balance them with the costs, and we have to look at the unintended consequences. If the unintended consequence of making public companies report more information is they stay private and report no information, are we better off? I'm not so sure. Let's look at another case, and I think this case is instructive because this case actually brings up a duty of loyalty claim, although the facts to me are remarkably similar, which sort of to me emphasizes the point that these oversight claims are neither fish nor fowl, neither care nor loyalty. So Stone v. Ritter dealt with AmSouth Bank, and AmSouth Bank, like most banks, like all banks, has to comply with anti-money laundering laws, AML. Basically, we don't want Ponzi schemes, terrorist activities, drug trafficking to be run through banks. The fact that banks are liable if these activities happen to them creates an incentive for banks not to permit terrorists and drug dealers and Ponzi schemers and fraudsters to use their bank. And if the banks are good policemen in this regard, well, hopefully that reduces the ability of people to run Ponzi schemes and traffic drugs and funnel money to terrorist organizations. So we have these anti-money laundering laws. And in order to comply with these anti-money laundering laws, banks, in certain conditions, have to file a suspicious activity report. Now look, I'm not an expert on this, so you could ask and I won't know what triggers a suspicious activity report or an SAR. I do know that in this case, a suspicious activity report should have been triggered based on the activities of a certain Lewis Hamrick and Victor Nance. So Lewis and Vic were perpetrating a Ponzi scheme out of AmSouth Bank, and apparently, again, I'm not an expert on this, apparently their activities, either in creating the account or the way they used the account more likely, should have triggered a suspicious activity report. And they didn't file the report. The bank did not file the report, and so when it became found out that Lewis and Vic, Mr. Hamrick and Mr. Nance were running a Ponzi scheme, well, the government came down on the bank, imposing fines and penalties. Sounds a lot like the Caremark case, where we have kickbacks perpetrated by employees, followed by fines and penalties from the Department of Justice. In this case, it was $50 million in fines. Now, again, that's only a fifth the amount of the fines in Caremark, but still a huge number for a much smaller organization to bear with. And AmSouth, I don't even know if they exist anymore. I think they're probably merged into, NCNB, which then got bought by Bank of America. But anyway, my corporate banking history is a little rusty. Point being that $50 million in fines was a significant amount. And in addition, in making these fines, the government said that AmSouth's compliance programs were inadequate. Oh. You don't want the government to say that about your compliance programs, by the way. That's usually bad. When the government fines you $50 million and says that you're inadequate, it's a bad day at the office. So that's what happened. But notably, the plaintiffs, of course, sued. That would be Stone here, Director Ritter et al. And the Stones were a couple who owned a substantial amount of shares, and they sued, and it was a derivative suit. right? Why a derivative suit? Because, again, the action harmed the company, harmed its reputation, harmed its book value, harmed its stock value. Those are harms to the corporation. So we have a derivative lawsuit through that process. And interestingly, the Stones even admit there were no red flags. The Stones admitted in their action, I'm not sure if it was in the complaint or later, but they admitted that the directors did not have actual knowledge of the wrongdoing. There were no red flags. But claiming that Caremark has increased the obligation of directors for oversight, increased the liability for directors, they claimed that the directors utterly failed to implement any sort of monitoring, statutorily required monitoring program, reporting or information controls that would have enabled them to learn of the problems requiring their attention. Effectively saying they should have known about this problem. And moreover, they would have known if they had gotten off their duff and put a compliance program together. So they alleged a breach of the duty, and the Chancellery Court dismissed the case. Why? Well, did they start as a direct suit? Is that why? Oh, yeah. They originally were dismissed because they did not make a demand on the board and did not argue for demand futility. They then refiled, appealing and claiming demand futility. So there's also a procedural. I didn't put that in the slides because we did that last lesson. Short on time. So there was an issue of not making demand on the board. There's, of course, a demand requirement. The Stones appealed, claiming demand futility, saying that the directors were not able to exercise their independent business judgment in this case because they would be liable for utter failure to set up these monitoring systems. And so the liability would depend, there's a whole complicated thing here. Do I want to deal with this? Give me 1 second to think this through. Because there's a complicated aspect here about the exculpation provision, which is interesting, but not central to what I want to talk about. I might come back to that. For those of you who read the case carefully, there's some interesting procedural tweaks and twerks about how the exculpation provision related to the demand futility. But since that was from 3 weeks ago lesson, I'm going to keep pushing forward with the result of this claim. But keep a note, that was sort of an interesting procedural quirk of this case, and maybe something I'll bring up next year in the section on the demand requirement. In any event, demand was not excused. And the court effectively was saying that the directors would not be liable here, that they were able to make an independent decision. And because the risk of liability was so low to them, they should have been able to determine whether or not to allow the suit to proceed, and therefore demand was not excused. Effectively, in other words, the court said that the directors would not be liable, that the probability of the directors being liable in this case was effectively zero. And so that's really the key thing, right? So I'm sorry about the flipping back and forth about it. But the contrast then to Caremark, in Caremark, the court approved a settlement. And again, the procedure is interesting to some, maybe not to you, but to some. And it's at least interesting because that was an approval for a settlement, and this was about demand excuse. But both had the same substantive issue. Is it possible that the directors would be liable because they failed to implement a monitoring system? In the case of Caremark, the answer was yes. In the case of Stone, the answer was no. So how do we distinguish between these two cases? Well, the major difference in this case was that despite the claim from the plaintiff that there was an utter failure to implement monitoring systems, those are the right words, the bank actually did have a system. Remember, what did the Department of Justice say? Did it say you had no system? No, it said their system was inadequate. What's the difference between no system and an inadequate system? Well, in the case of an inadequate system, the directors had acted. They had set up a system. With 20/20 hindsight, that system proved to be inadequate. But they didn't lack an information system. The information system did not function properly in this instance. And maybe with 20/20 hindsight, they would have set up a different system. But they didn't fail to set up a system. They set up a system that turned out not to function as desired. And they didn't do it in bad faith, right? Remember, the directors are allowed to be stupid. They're just not allowed to be lazy. So were they stupid or were they lazy? In this case, well, the court said maybe they were stupid, but they weren't lazy. They made a monitoring system. The monitoring system was no better than our friend Alfred E. Newman here would come up with, but that's who the shareholders appointed to be their directors, and that's the system that they came up with. They did it in good faith. And it had the following important insight. A bad outcome does not imply bad faith. Just because things turned out badly doesn't mean people didn't try. I mean, has anyone here ever tried and failed? Sure, right? And if every time a director tried and failed they were liable, what would the business judgment rule even mean? It would be totally eviscerated. The stockholders did not create a reasonable doubt that the board could not properly exercise its independence. Again, demand was not excused because there was no possibility of personal liability. Again, that's a procedural quirk that I'm not taking the time to drill into. It is an important distinction for the demand requirement, but I want to focus here on what made this different as a matter of a breach of oversight claim. I'll bring in a quote from the court that might elucidate. This is Justice Randy Holland from Delaware. He said, where directors fail to act in the face of a known duty to act, therefore demonstrating a conscious disregard for their responsibilities, they breach their duty of loyalty by failing to discharge in good faith. So a plaintiff has to show a failure to act in good faith, which is now couched as a duty of loyalty violation. Otherwise, the exculpation clause will apply and the directors will not be liable. A failure to act, not a bad action. And again, notably, Caremark did not have an exculpation clause, to my knowledge. Here, there was an exculpation clause, making the duty of care claim ineffective. And here, there was also the procedural distinction that demand is not futile if the directors would not be personally liable, which is why the demand requirement is kind of weird. You almost have this quasi-merits conversation before depending if you can proceed on a procedure. But we, at least from this case, now that we see a case that succeeded and a case that failed, we have a clearer standard, which I like to call the utter failure standard. I like this slide. The utter failure standard. You remember this one, right? So what is the utter failure standard? The board will only be liable when it utterly fails to implement a reporting system or a control system, as was the case in Caremark. There was an utter failure to implement any system. However, having implemented such a system, the fact that it didn't work properly is not going to produce liability for the directors. They didn't utterly fail, they just failed. We could think of it as maybe they were negligent, maybe they had misfeasance, maybe they didn't meet their standard of conduct, but they met their standard of liability. They had a meeting, they talked about setting up a system, they set up a system, wasn't a very good system, and maybe they weren't very good directors. But we don't judge them on that basis. They weren't very good directors, and the shareholders now want to sue? Well, hey, shareholder, you're the one who appointed the guy. You should have thought of that before you gave him the job, is effectively what we see as a consistent theme running through these. This was not an utter failure, not in stone. There was an information reporting system. It was supposed to permit them to monitor the compliance. It didn't work. It didn't work. They tried and they failed. If anything, this is a duty of care issue, right? They tried something and it didn't work. And even if there might have been some liability under the duty of care, the exculpation provision that AmSolve had would have excluded that. As a result, and again, this is interesting. Like, just as your point was, I thought a settlement didn't mean anything. No, the nature of a settlement approval by Delaware courts means a settlement approval has some aspect of judging the case on its merits. Likewise, making a decision about demand excuse is a decision on the merits, at least to an extent, because it's asking, is it possible that the directors would be liable? So, the plaintiffs did not show a failure to act in good faith. And so it wasn't a duty of loyalty violation, according to this case. It was couched in the duty of loyalty. So the exculpation clause would apply, so demand is futile, so the court dismisses. We don't have an utter failure. The liability test is the same, but the result is different. So let's recap. Under the board oversight provisions, we first have to understand what are the functions a director should do, because a failure to do functions that are required can lead to liability. Now, to me, it's a little different than the duty of care, because in the duty of care, we have a commission, a positive action. And that positive action can lead to liability in only a very minority of situations, which are effectively eradicated by an exculpation clause. Here we have something a bit different. We have a director that had an obligation to do something and instead did nothing. So we have to begin with what are the obligations directors have to understand when they didn't meet them. In the classic standard, as discussed in Francis, or Pritchard if you want to call it that, the standard of what directors have to do was very low. And we do have an instance where even that low level was not met. But that has been raised, at least to a certain extent, by Caremark. And now the standard is directors have a duty to act both when there is something, a violation that they know about or that they should have known about. And the liability for directors for violations they should have known about creates a new duty or obligation, however you want to call it, to create monitoring systems. This is why I call it a duty of oversight. I think it's a new duty that they have an obligation to create monitoring systems in order to become aware of things they otherwise would not know but should know about. Otherwise, they will be liable for things they did not know about when they should have become aware of those things. And Sarbanes Oxley has created statutory requirements, including some that we discussed, including audits and mostly this Section 404 internal controls report, which is actually very onerous on top of all that. So again, I have a theory that this is the duty of oversight. Cases don't always treat it this way. How can you treat this? Well, quite frankly, duty of care claims never proceed anymore. Most of these businesses have an exculpation clause, and so no shareholder is going to make a duty of care claim in the face of an exculpation clause. They'll have to make a duty of loyalty claim. How do you make a duty of loyalty claim out of a failure to do something? I mean, as we'll see in our, not next week, but our next major lesson, duty of loyalty claims are usually when a director has a conflict of interest or gets a personal benefit from a transaction. Now, I think there is a kind of quirky way to think about it, that maybe the director was on their yacht sunbathing and drinking a martini instead of doing the work at the firm that they should have been doing. And maybe in that way it's a breach of loyalty, because instead of doing the work of instituting the monitoring system, they were enjoying their free time. But I think that's pretty attenuated. I don't really see how it's really a loyalty claim. What I see is plaintiffs trying to squeeze this into the loyalty dimension, because most of these companies have some type of exculpation clause. And maybe we want to think of this as a separate duty. And I don't know if that's helpful, but it's at least a way of maybe reframing how we understand liability for directors. In terms of what you're going to be presented with, I mean, these cases do present very obviously, because in all of these cases, you will have the following fact pattern. The corporation is sued or fined or penalized for some type of legal violation. Non-compliance with any money laundering laws, non-compliance with Foreign Corrupt Practices Act, non-compliance with emission standards. Look at Volkswagen, right? Those sort of things, you know. And these have to be huge systemic violations throughout the company where there's like vast wrongdoing and huge liability. So that's kind of fact number one. And then we're going to see that the directors did nothing to even see that this would have happened. If they had actual knowledge and did nothing, that's really easy. That at that point might fall into a duty of care claim because we have bad faith, right? A director who knows for sure that the corporation is manipulating emission standards or bribing foreign officials and does nothing, is probably acting in bad faith by staying silent, so maybe we don't even have to worry about exculpation. Remember, you can't exculpate for bad faith. But we're talking about major claims. More likely, we'll just see that the board did not know of the claim, but a plaintiff can colorably argue that they should have. That if they had been looking, if they had been testing and checking and following up, they would have become aware of this claim. And the failure to become aware of a violation which has caused great harm to the company, where they had the ability to do so and utterly failed to implement any system to monitor for that, can result in an oversight violation, usually couched in the duty of loyalty, because the duty of care won't get you there unless there was bad faith. Maybe there was a bad faith reason they didn't set up a monitoring system, but those would be really unusual facts. Usually they just didn't think of it and just didn't do it. So anyway, that's what I'd call the duty of oversight. You can think of it as an aspect of the duty of care or an aspect of the duty of loyalty. It's a relatively minor piece in the puzzle. The larger pieces, of course, are the traditional care claims. And as we'll see, the real action where directors actually lose is loyalty claims. And as an advisor to corporations, what do you need to know? You need to know that directors should create monitoring systems to avoid legal violations by the company. They need to at least have a way of becoming informed, and they need to make a good faith effort that those systems work. And usually the way that works is you hire a guy like my buddy Ailey who sets up these systems. And if you didn't think you had to do that, you sure do after Sarbanes Oxley, because it says so in the statute. And you have to at least comply with Section 404 if you're a public company, and private companies probably have some of those obligations as well. So with that, we'll close for today, and when we'll come back, we'll talk a little bit about risk management. I'm going to talk about a Citigroup case, and what's interesting about Citigroup is basically, please read it, we'll talk about it, but in Citigroup there was business risk, and the directors did not prevent business risk from destroying the company. This is different than legal risk for important reasons. I'll invite you to think about why, and hopefully we'll have a nice conversation about the financial crisis. So I will see you next Wednesday.